a little bit. Yeah. See, that's what I was worried about. That echoing. Yeah, unless you think that we can turn the volume down on that. Okay.
Okay, good evening. Welcome to DPH tonight. I'm Ron Horseman, Assistant Director for the Division of Administration and Financial Management. Appreciate you all coming out tonight. Wanted to introduce Amy Bensonhaber. She is from the Attorney General's office, I think Assistant Attorney General, and she's going to present tonight an overview of our open meetings. So I'll make her welcome, and again, I appreciate you all coming. My email address is at the bottom of the screen, so if you have any questions as we go through that maybe you don't want to speak up for whatever reason, just email those to me, and I will get them to Amy, and she can respond to those as we go. But she'll have her own format. I think she said openly, if you have questions as she presents, ask them at that time, and she'll be glad to answer them. So again, thank you for coming. I'll turn it over to Amy. Thank you.
Thanks, Ron. Thank you so much for inviting me here tonight. One of the chief responsibilities I have in the AG's office is to try to educate the public, and specifically public agencies, about their duties under the open meetings law. Through the years, I feel confident I've spoken to many of you, or some of you, in person, by telephone. Issues arise daily in this area of law, and very often it's a kind of a crisis situation where you need an immediate answer. So I'm always happy to try to assist you if that's something you'd be interested in availing yourself of. And therefore, I've provided you with some contact information so that you can contact me at my email address, or preferably at my phone, because I'm not a very good typist. But ultimately, I'm here tonight to try to give you an overview of the statute so that you can avoid some of the pitfalls that agencies frequently fall into. And let me begin by saying I came to the AG's office in 1991. At that time, the open meetings law was being addressed in advisory opinions by the Attorney General's office, but in 1992, the legislature assigned to the Attorney General the role of dispute mediator, so that we act, in essence, as the first line of review, as almost a court in adjudicating disputes that arise under the open meetings law. And that's what I've been doing in these many years that I've worked for the Attorney General's office. Very often people will avail themselves. They will find that they've observed something they believe to be a violation of the open meetings law. They believe they have a right to pursue that issue, and they do so by filing an appeal with the Attorney General's office. I want you to understand what our role with regard to this law is. I'll discuss it a little more later, but just so you understand my background, I have been adjudicating these disputes, basically acting as a dispute mediator in open meetings challenges since 1992, when the law was amended to give our opinions in this area the force and effect of law. And so what typically happens is an individual attends a meeting or looks and sees that a meeting is occurring and there's been no posting and no advance notice of that meeting, and they know that that could be potentially a violation of state law. They file their complaint with the agency. They get a response from the agency, or they don't receive a response from the agency, and based on that, they decide that they want to pursue their remedies through the Kentucky Open Meetings Law to the Attorney General's office. They do that at no expense. They have no filing fees. They don't have to retain an attorney, and they get a resolution of their issues within 10 business days. So Kentucky has a pretty interesting law in that respect. We get quick resolution of these disputes. And as I said, our decisions, if not appealed to circuit court, are legally binding on the parties. So the thing I want to kind of encourage you to take seriously and never to ignore is an appeal, the notification of an appeal from the Attorney General's office. That's your opportunity to try to defend your agency's position. And tonight I'm going to hopefully provide you with some of those defenses. The allegations can be anything from inadequate notice of a special meeting to an unlawful closed session or a secret meeting of a quorum of the members of a public agency. The allegations are far-ranging, and I also have a little quick and dirty little reference at the end of this that identifies the 10 most common allegations that are leveled against public agencies. And as I said, most importantly, you'll get a lot of information tonight. The resources that are available to you, obviously, are your agency's counsel. We have a document on our website called Your Duty Under the Law, which you hopefully have received from the agency, the county or the city that you serve. That is a responsibility of local officials under certain circumstances to distribute that information. You may already have Your Duty Under the Law, but if you don't, it's a pretty valuable resource because it breaks down the law in hopefully simple terms and tells you, again, the major pitfalls that agencies most commonly fall into. And then finally, as I said, I would be happy to try to help you if the occasion presents itself that you feel like I could be useful to you. If you want to contact me at my telephone number or at my email address. We begin with the basic policy set forth in the statute that the formation of public policy is public business and shall not be conducted in secret, and that the exceptions that exist in the law have to be strictly construed. Again, that's sort of the underlying principle that informs all of the decisions issued by the Attorney General, is that we're going to exercise a presumption in favor of openness. If ever there is any doubt in your mind about whether it's the proper course of action, an agency should always err on the side of openness, and that's reflected in this statement of legislative policy that appears in the statute. The statute over time has been construed by the courts, not as frequently as the open records law, which some of you may also be familiar with. Open records tends to be the more heavily litigated area of law, but there has been a body of law that's developed over time in the area of open meetings, starting in the earliest days of the law. And one of the most significant cases is cited here, Floyd County Board of Education v. Ratliff. And what is significant about that case is that the court recognizes that the goal, the express purpose of our law is to maximize notice of public meetings and actions, and that the failure to comply with the law violates the public good. In a very early opinion cited here, a 1979 opinion, the court also said that statutes that are enacted for the public benefit must be interpreted most favorably to the public. So again, that's sort of the principle that informs our decisions when we write our open meetings decisions. There's one very simple mandate under the statute. Anytime you have a quorum of the members of a public agency present and there is a discussion of public business or action is going to be taken, that meeting triggers the requirements of the open meetings law. All of the requirements of the statute have to be observed. That meeting has to be conducted in a public forum. So again, if you have a quorum of the members present and you have a discussion of public business, or you have an agency that's going to take action, you have triggered the requirements of the open meetings law. That provision of law has been construed over time to prohibit telephonic meetings. In other words, you can't have participation. You have to be able to enable the public to view the meeting, to see with their eyes, and to listen with their ears. All of these meetings have to be conducted publicly, so telephonic meetings are impermissible under the statute. One of the big questions that comes up in recent times has been remote participation. We might have a serviceman overseas who serves on the board, or we might have someone who is vacationing, or someone who is otherwise unavailable to actually be physically present for the meeting. In general, I can tell you that there is an older opinion of our office, predating a lot of the new technologies that we have, that discourages that practice. It basically says remote participation is not permissible except to the extent that the individual could listen and perhaps comment. He or she couldn't be counted toward the quorum. He or she couldn't vote. So I can tell you that I think that there may be an opportunity at some time at some point in the near future for us to revisit that issue, simply because technology now permits us to enable the public not only to hear a person but also to see the person, which is what the law requires, the ability to both see and hear every member of the public agency. So the recurring question we get is, well, what about Skyping? Can't we just Skype in that member from, Sudan, someone serving, in the military, and they're, they're serving in the Middle East, and they want to be participating in the public's business. They want to continue to discharge their duties as public officials, but they're at a remote location. Well, at this point, I can tell you there is no specific legal authority recognizing the right in Kentucky for a person to attend the meeting, to be counted toward the quorum, to vote. But I would say keep your eyes open, because I think that's a possibility. At this point, Skyping has not been formally approved as a means of bringing someone in remotely, to a member into the meeting remotely. But it is a possibility as time goes by and that technology is more recognized, that will be a permissible practice. When I talk about the requirements of the presence of a quorum, a discussion of public business, or action being taken, it's a common defense that is raised by public agencies that we didn't really violate the law because we didn't take action at this meeting. We met and we discussed public business, but there was no action taken, so there's really no violation. Well, in reality, the statute makes very clear that it's either a discussion of public business or action taken. It doesn't require both. So if you have a quorum present, if only to discuss public business, even if you're not going to take action, you still trigger the requirements of the statute. You still need to be thinking in terms of making your meetings public, giving notice to the public, ensuring the right of the public to attend. Public meeting is very broadly defined in the statute, so there really should be very little doubt to public agencies, how all-encompassing the statute is. All gatherings of every kind, regardless of where the meeting is held, whether regular or special, informational or casual gatherings held in anticipation of or in conjunction with a regular or special meeting. Again, an all-encompassing definition, and for what it's worth, the term public agency is equally broadly defined. It contains 8 subparts. Clearly, there's no issue about the applicability of this law to your agencies, but what has become an issue, and I think has been identified as an issue for local boards of health, has been the appointment of committees, subcommittees, ad hoc committees, advisory committees. Well, since the law was enacted, the statute has defined a public agency as any committee, subcommittee, ad hoc committee, advisory committee. That's a separate and independent public agency. So if the board creates a committee, even if that committee's role is purely advisory, that committee is itself a public agency and subject to all of the requirements of the open meetings law that are applicable to the body that created it. Its quorum is based on its composition, not the composition of the body that created it. So if there's any lingering doubt about the applicability of this law to committees, the statute makes clear. It's actually defined in the statute. I wrote that down, and KRS 61805 subsection 2G clearly defines as a public agency any committee, ad hoc committee, subcommittee, advisory committee established, created, and controlled by a public agency. The term public meeting has been construed to extend to work sessions, retreats, any gathering of a quorum of the members of a public agency at which public business is discussed or at which action is taken, regardless of what it's called. So again, calling something a retreat, calling something a work session doesn't remove it from the application of the law. It is still subject to the requirements of the statute. It is, however, permissible for a quorum of the members of a public agency to attend a conference. There's a line of opinions issued by the Attorney General recognizing that it does not constitute a violation of the open meetings law for a quorum of the members of a public agency to attend a conference sponsored by an outside entity. I believe when I was talking to Ron before the meeting began, I think there's something called KPHA? KPHA. If KPHA were to sponsor a gathering, an opportunity for training, and a quorum of the members of a board attended that training, that would not necessarily constitute a violation of the open meetings law, so long as the board did not discuss local agency business. In other words, you come for purposes of education, you gather that information and that knowledge, you avoid discussion of your agency's business at that conference. But the attendance at the conference itself, even if a quorum of the members are present, is not a violation of the statute. Again, assuming that the members avoid discussion of their own agency's specific business. It, as of course, in smaller communities becomes a problem, especially with smaller agencies, but it can become a problem if you have a quorum of the members of a public agency who, for example, attend the same church, appear at the same social gathering or sporting event. Obviously, the statute doesn't prohibit that quorum from attending those church services or that sporting event or that social gathering. But again, when you're there, if you start to gather into a little group and you realize suddenly there's a quorum present, you need to avoid discussion of your agency's business, because again, anytime you have a quorum of the members of the public agency present and there's a discussion of public business, you're triggering the requirements of the statute. And as hard as it may be to believe, there are instances in which an agency is challenged on that basis. They go to a restaurant to have lunch, someone overhears the conversation, and they bring in they level a complaint against the agency that they're violating the open meetings law. And quite frankly, if they were discussing public business, that could be a violation of the law. Okay. The statute imposes some very basic requirements on public agencies. I don't want to dismiss these because they're extremely important, but they're very basic concepts. Agencies must conduct their meetings at times and places convenient to the public. They have to adopt a regular meeting schedule and, upon request, make a copy of that schedule available. They have to record and make available minutes of their meetings. They have to permit public attendance at their meetings without imposing any conditions other than those necessary for the maintenance of order. And they have to permit news media coverage. Now again, those are some fairly basic principles. They have over time been construed in a variety of contexts to require certain things, and I'd like to share some of those with you. First of all, the difference between a regular and a special meeting. You have this requirement in the statute that you adopt a schedule of regular meetings by ordinance, order, resolution, by law, or by whatever other means may be required for the conduct of business. And then, again, upon request, to make a copy of that schedule available. Any meeting that does not appear on that schedule of regular meetings or a rescheduled regular meeting is a special meeting. So again, let me emphasize, anything that's not on your schedule of regular meetings or a rescheduled regular meeting constitutes a special meeting, triggering all of the notice requirements that exist in the statute, which we'll discuss in a minute. As far as the minutes of the meeting, it's important that the minutes, just at a bare minimum, record any actions taken at that meeting. Some minutes are a lot more detailed than that, but at a bare minimum, the statute requires that you contain an accurate record of votes and actions taken. If the vote at the meeting is not unanimous, it needs to reflect how each member voted. Just basic rules, Robert's Rules of Order kind of analysis in general about those minutes. Those minutes have to be available for public inspection no later than the next meeting of the public agency. Once they've been approved, obviously they're accessible to the public, whether the person makes an open records request or you just make copies available to him. You don't have to take minutes of a closed session, and of course if you do voluntarily take those minutes of a closed session, they are not accessible to the public. You may withhold them from inspection under the open records law. But as I said earlier, committees are public agencies in and of themselves. Even if they're advisory, you need to have minutes of those meetings, advisory committee meetings, reflecting at least that the meeting was convened, a quorum was present, and that the meeting adjourned. Of course, anything more you want to add is certainly permissible, but at a minimum, even an advisory committee that doesn't take action needs to have minutes that reflect that a meeting took place. The Open Meetings Act doesn't require agencies to tape their meetings, but if they do tape their meetings and they direct the creation of a tape of the meeting, they use agency equipment to create that tape is immediately accessible or within 3 business days of a request under the Open Records Law. That tape has to be made available to the public. There was a line of opinions in the past basically treating that as a preliminary document. In the mid-90s, the Attorney General reversed that line of decisions and now takes the position that a tape of a public meeting is a public record, and unlike the minutes that you might have to wait a month to get, should be immediately accessible to the public, again, upon receipt of an open records request. I'm often asked, well, how long do we have to keep a tape if we do make a tape of a public meeting? And this is where records management, records retention, under Chapter 171 of the Kentucky Revised Statutes, and records access under the Open Records Law, Chapter 61 of the Kentucky Revised Statutes, kind of intersect, where you ask the question, how long do we have to keep a record? That you're witnessing the intersection of those two laws. Basically, the statutes, the Kentucky Commission, what I serve on, Archives and Records Commission, has established a retention period for the tapes of a public meeting. They have to be kept for 30 days after the minutes are transcribed and approved, and may thereafter be destroyed or recycled. But if there's any dispute about the minutes, or if there's a pending open records request, you can't destroy it after 30 days. So the rule of thumb is 30 days unless you have a pending open records request, 30 days after the minutes are transcribed and approved. And then you can destroy or recycle the tape. But if there is any kind of pending dispute involving access to those minutes or involving the content of those minutes, you obviously would want to keep those records for a longer period of time until that matter had been fully resolved. Okay. One of the provisions of the statute talks about the right of the public to attend. No conditions other than those necessary for the maintenance of order can be imposed. No member of the public can be required to identify himself or herself in order to attend a meeting. That provision of law has been construed to basically say you can have a voluntary sign-in sheet. It's permissible to lay that sheet out there and encourage people to sign it, but you can't condition an individual's right to attend the meeting on their willingness to sign that attendance sheet. So if you have an attendant or a sign-in sheet, do not assume that you can condition that person's right of attendance on their willingness to identify themselves. The statute expressly states that no member of the public can be required to identify him or herself in order to attend a public meeting. And then finally, I did want to mention too, one of the common misconceptions about the statute, one of the things that's very hard for me to explain to the public is our law guarantees the right of the public to see what's transpiring with their eyes, to listen with their ears, but not to speak. In other words, public agencies are not required by the Open Meetings Law to provide for a section of the meeting dedicated to public comment. That is not to say that that is not a practice that we should encourage that practice. It's just that there is no enforceable right under the statute that a person could assert that they were denied the right to speak at a public meeting, because again, the Open Meetings Law only guarantees the right of the public to see with their eyes and to listen with their ears. And as far as news media coverage, basically the idea that if you have a particularly high profile issue and the local news station sends out a reporter with a camera, that must be permitted. The significance of that is that in the mid-90s, again, the Attorney General's office kind of expanded that requirement, hopefully properly, to include members of the public. Very often a person would come with a tape recorder simply wanting to tape the meeting, and public agencies would object, no, we don't have to let you do that. In the mid-90s, the Attorney General issued a line of opinions to the President that basically recognized that the right of the news media to tape a meeting extends to the members of the public. The only exception to that would be if someone got really offensive and started poking microphones in people's mouths and was really disruptive, then there might be a different analysis. But in general, the public has a right to tape their meeting. I did want to mention too that in the 2013 session of the General Assembly, there was a slight amendment to the statute just clarifying what I think was already implicit in the law, the requirement of that agencies have to conduct their meetings at times and places convenient to the public and provide meeting room conditions which, insofar as feasible, allow effective public observation. In the 2013 General Assembly, the law was slightly amended to say basically when you're doing that, when you're thinking in terms of meeting room facilities which, insofar as feasible, allow effective public observation, you need to specifically think about space requirements, seating capacity, and acoustics in choosing meeting locations. So we now have something I think that was implicit in the law is now explicit in the law, and the General Assembly has made clear that those things have to be considered in choosing a meeting site. There is a case from 2004 that dealt with the precise issue of times and places convenient to the public. A big festival was going on. I think this was in Boone County. No, obviously it was not Knox County. And the meeting site was what the court referred to as literally the epicenter of activity, making it difficult for people to enter and leave the building, making it difficult for people to access the meeting. But ultimately the court said there, no violation. The Open Meetings Act is designed to prevent government bodies from conducting business at such inconvenient times or locations as to effectively render public knowledge or participation impossible, not to require such agencies to seek out the most convenient time or location. And in the case of this festival in Knox County, there was nothing to indicate that persons wishing to attend or participate in the proceedings were effectively prevented from doing so. So in Knox County, the court afforded the agency some latitude and basically said, you don't want to do something that's specifically intended to prevent public participation or knowledge of a meeting, but you don't have to always choose the most convenient time or location. Quite frankly, there's no time or location that's going to be convenient for everyone. So you just try to do your best to ensure the broadest possible participation in the meeting. Okay, we talked about regular and special meetings. We talked about, first of all, agencies need to establish a schedule of regular meetings. Anything not on that schedule is a special meeting. A rescheduled regular meeting is a special meeting. Did I say that right? Anyway, okay. When you have this need to call a special meeting, you trigger certain requirements under the statutes, and those can basically be broken down into 3 subsections: the content of the meeting notice, delivery of the meeting notice, and posting of the meeting notice. The statute says that the presiding officer or the majority of the members can call a special meeting. That's never, to my knowledge, been an issue. But what becomes an issue is the adequacy of the meeting notice. And Kentucky's law makes very clear that that notice, that written notice that has to be posted at least 24 hours before the meeting is to occur, has to include date, time, place, and agenda. And I want to emphasize that last part. Sometimes there's a misconception that that agenda is a separate document. That meeting notice, that written meeting notice that's posted at least 24 hours before the meeting has to include not only date, time, and place, but also the agenda. And that agenda has to contain specific agenda topics. It can't be broadly worded like old business, new business. It would have to have specific agenda topics rather than broadly worded general agenda topics. The goal here, again, maximizing notice to the public, is to let the public know why it is your meeting, the special meeting has been called. Do they have sufficient interest in that topic to want to attend the meeting? So if you have these broadly worded topics like, district board business, that doesn't tell the public enough about why you're calling that special meeting. So the agenda has to be included in that written notice that is sent to the members, sent to the media, and posted. And it has to include that agenda with specific agenda topics. That's a fairly common complaint that the public makes. So the requirement of delivery is basically every member of the public agency and any news media organization that has a request on file to be notified has to receive that written notice at least 24 hours before the meeting takes place. Again, the statute specifically says the media organization needs to have a written request on file to be notified. It spells out specifically how often the agency can require them to resubmit their request for notice of special meetings. But you're technically not required by statute to notify every local media outlet. Certainly, there's no prohibition on that, and it's obviously, again, a good practice, not a bad practice. may be a difficult practice if it's Louisville or Lexington, but ultimately, the only specific legal requirement is notice to the members, notice to the media that has a request on file to be notified. Again, that notice consisting of date, time, place, and agenda. And in addition, the requirement that that notice be posted again at least 24 hours before the meeting in a conspicuous place accessible to the public in the building which houses the headquarters of the public agency, as well as the building where the meeting will be held. So if those are two different places, you're going to have two different posting requirements. If it's one place, just one posting requirement. But again, the building that houses the headquarters of the public agency and the building where the meeting will be held. And that could become an issue if you had a particularly newsworthy or hot button issue that you were dealing with and you expected an enormous turnout at your meeting and you had to move it from the regular location, the building that houses the headquarters of the public agency. Again, just so long as you post it in both locations, but if you're holding it in the same place as your headquarters, you only have that one posting requirement. But again, 24 hours before the meeting, you have to be sure that notice has been posted, date, time, place, and agenda on that posted notice as well. There is a third kind of meeting which the statute recognizes but has been rarely recognized as permissible, an emergency meeting. It hasn't come up with a great deal of regularity. Very often, when you think of an emergency, you might think of a natural disaster, and within recent memory, we've had occasions where it's been necessary, I'm sure, for local agencies to call emergency meetings. The Attorney General has basically said, that an example of an emergency would be a natural disaster or civil unrest, some sort of real problem in the community with law enforcement or something. So the bottom line is, there might be a situation that called for that, but even in those rarest of occasions where the situation calls for it, the statute still states that you should try to comply with the notice requirements in the statute. Now, if you do have to waive those requirements because there is some threat to essential services or something like that, you can waive those or abandon those regular notice requirements. But again, bearing in mind that's going to be the rarest of occasion. I think I can only recall one or two cases where it's been approved by the Attorney General in a decision. It's never been presented to the courts. Okay. Since July 15th of 2008, it has been permissible for public agencies to transmit written notice of special meetings by email. We come into the 21st century, we're letting our public agencies discharge their duties under the statute to notice their members on special meetings by email, but you can't just assume that's the case. You can't just assume that's permissible. You have to be sure that any member or media organization that you send the notice to by email has a written request on file with the agency expressing their preference for an email notification, and also that they've included their email address. So again, don't just assume because the statute now permits email notification that you can default to that every time. That member has to have, or media organization has to have a written request on file to be notified of special meetings by email, and they have to have included their email address. All right, so you've got your meeting, you've called your meeting, and everything's cool. I think I didn't mention one thing that is very important, so I'm sorry, I'm going to need to go back for just a minute. Two things. On the notice of special meetings, I apologize, but I do want to mention, very often agencies will say, okay, well, we didn't comply with the specific notice requirements in the statute, but we did post notice on our website, and we did mention it at the previous meeting that we would be holding a special meeting the next Wednesday or something. Those kind of compliances with the notice requirements are all well and good. They can be added to the requirements of the statute, but they don't relieve the agency of its duties to comply with the specific notice requirements. In other words, they can be in addition to, like web posting of meeting notice, announcing it at the meeting immediately preceding the special meeting. Those can be in addition to, but not in lieu of, the specific notice requirements of the statute. I did want to mention that, as far as what you can discuss at a special meeting, you only want to discuss those specific agenda items that are listed on the meeting notice. You can't go outside the agenda. And since those agenda items have to be very specific, just bear in mind that you're kind of tying your own hands if you do a lot of your business by special meetings, because again, you're restricted to the agenda items listed on your meeting notice, and those agenda items have to be very specific. There is no specific legal requirement that agencies have an agenda for regular meetings. I think virtually every agency does, just to keep the process flowing, just to keep the meeting going along in an organized fashion. But there's no statutory requirement that you have an agenda for a regular meeting. And if you do have an agenda, you're not legally bound to only discuss those topics. So I'm sorry, I did kind of get a little bit ahead of myself. But I did want to mention those things because they're kind of areas that agencies sometimes have a little problem with. Make sure I'm not. Yeah. Okay. So you're conducting your meeting, and the presumption is that the majority of the business to be discussed is going to be discussed publicly. We're always going to err on the side of openness. That's sort of the legislative mandate. That's how the statute has been construed through the years. But on occasion, the General Assembly recognized back in 1974 when they enacted this law, there are going to be occasions when public agencies have a legitimate need to go into closed session to preserve some sort of governmental interest that confidentiality is required for. And so when they enacted the law back in 74, they developed this little list of exceptions to the general rule of public open meetings. Before you go into closed session to discuss one of those topics, it's critical that you be aware of the requirements for going into closed session. Very often this is the issue that's been raised, is that the agency failed to give adequate notice to the public of what it was going to be discussing in that closed session. And the statute does set forth the requirements. Those requirements are notice in an open public session of the general nature of the business to be discussed, the reason for the closed session, and the specific exception, statutory exception authorizing the closed session. So you have three basic things that you need to set forth before going into closed session. The general nature of the business to be discussed, not with such specificity that you defeat the purpose for going into closed session. Generally speaking, what it is you're going to be discussing, the underlying rationale that supports the reason for going into closed session, and the exception that authorizes the closed session. I wrote a couple of examples when I was preparing this today, and of course these are just examples and kind of the hypothetical, but for example, if you were thinking in terms of litigation, your agency had been sued or was suing someone, something along the lines of move to go into closed session pursuant to KRS 61810(1)(c), that's the statute, to discuss pending litigation against XYZ Construction Company, that's the nature of the business to be discussed, and to protect the agency's legal strategy in that action. That's the reason for the closed session. So you have a general description of the business to be discussed, to discuss pending litigation against XYZ Construction. You have a citation to the statute that authorizes the closed session, KRS 61810(1)(c), the litigation exception. And you have kind of a general statement of the rationale, the reason for the closed session, to protect the litigation strategy of the agency. Clearly, you don't think agencies shouldn't have to be in a weakened position relative to litigation simply because they're public agencies. They have the right to assert, those types of things that are protected by the attorney-client relationship. But again, it has to be in the context of proposed or pending litigation. With regard to the personnel exception, here's another example. Move to go into closed session pursuant to KRS 61810(1)(f), which is the personnel exception, to discuss qualifications of the applicants for the vacant director's position and to protect the reputational interest of the applicants not appointed. So you've cited the exception 61810(1)(f), you've described the general nature of the business to be discussed, the qualifications of the applicants for the vacant director position, and you've given the reason for the closed session, and that is to protect the reputational interest of applicants not appointed. And again, I'm giving you those by way of example. Obviously, you're free to frame your motions in any way you want to do that, but before going into closed session, that kind of litany has to be stated. And of course, you have to have a motion in open session that's carried by a majority. You can't take final action in a closed session, and the matters discussed in that closed session have to be strictly limited to the matters publicly announced in open session. So don't go into closed session to discuss personnel and then discuss litigation. Be sure to restrict your discussion in that closed session to the matters publicly announced in open session. Case law, again, addresses some of this and just makes clear, again, that the courts are on board with this idea that the agency has to state the specific exception contained in the statute, which is relied upon in order to permit a secret session, and give complete notification in the open meeting of any and all topics which are to be discussed in the closed session. And again, the older case, Reed v. City of Richmond, in the open public session, you have to describe the general nature of the business to be conducted in the closed session and the reason for the secrecy. So, bearing in mind that you don't want to say so much that you've defeated the purpose for going into closed session, in general, you just want to be sure to observe those requirements, because that is a very, very common allegation of violation of the open meetings law. I'm not going to try even attempt to go through all of the exceptions to the open meetings law. There are 13 exceptions. Many of them are very agency specific. There's one that for discussions of the parole board. There's some that are very agency specific, but there's some general ones that get cited with regularity. Just bear in mind again that the statute itself says the exemptions have to be strictly construed, and we have this case law recognizing that they should be narrowly construed and applied so as to avoid improper or unauthorized closed, executive, or secret meetings. So just keep in mind, narrowly construed, make sure if you're going to invoke that exception that it really does support the position that you're taking for the closed session. So I won't go through a lot of them. I think I've got 5 listed here. Deliberations on the future acquisition or sale of real property by a public agency, but only when publicity would be likely to affect the value of a specific piece of property to be acquired for public use or sold by the public agency. Again, the situation would be, the agency shouldn't be deprived of its competitive position in the sale of real property by having to have public discussions of what their lowest asking price might be. I mean, you want to be sure that before you invoke this exception that you haven't already disclosed what the purchase price is going to be. It's only in those occasions where the public's financial interest would be directly, the confidentiality is only permissible when the public interest would be directly affected financially. So if the terms of the purchase or sale have been disclosed, the exception is not available. Again, this one doesn't get cited that often, but it might have some application. I just tried to pull the ones that I thought had the greatest application. This is the one that is most often invoked. This, along with the personnel exception. Discussions of proposed or pending litigation against or on behalf of the public agency. This one has been heavily litigated through the years. There are some significant body of case law and Attorney General's opinions dealing with this particular exemption. What's most significant here is this is not just because the attorney wants to tell you something. Your attorney needs to share some research he's done on a particular legal topic with you. This, according to the statute itself and according to the case law construing it, is limited to matters commonly inherent to litigation, such as preparation, strategy, or tactics. It can't be extended beyond that. The exception should not be construed to apply anytime the public agency has its attorney present or where the possibility of litigation is still remote. So the statute does apply if it's a threatened litigation as opposed to pending litigation, but the litigation has to be something more, the possibility of litigation has to be more than remote. There's a very recent case within the last 6 months, Carter v. Smith, where the court basically said there must be a direct suggestion of litigation conditioned on the occurrence or non-occurrence of a specific event. The remote possibility of litigation is not enough to trigger the litigation exception. And again, it's going to be available to the agency to protect discussions of matters commonly inherent to litigation, such as preparation, strategy, or tactics. Okay. The personnel exception is the exception that permits public agencies to go into closed session to discuss matters which might lead to the appointment, discipline, or dismissal of an individual employee, member, or student. It does not permit, and expressly states that it does not permit, discussion of general personnel matters. So we're basically thinking here, with regard to litigation, we're thinking about litigation strategy, protecting our litigation strategy. With regard to the personnel exception, we're thinking about reputational interests of individuals. So we're limited to discussions of appointment, discipline, or dismissal of an individual employee member or student. It can't be expanded to include resignation, renegotiation of a contract, any kind of dispute about benefits. It has to be basically appointment, discipline, or dismissal. And again, what we're protecting here is reputational interests. Both the Open Records and the Open Meetings Law contain sort of catch-all exceptions for other confidentiality provisions that exist outside the Open Records or Open Meetings laws. In other words, you have a body of law developing through time that recognizes that certain types of records need to be protected from public inspection. At the federal level, of course, the one that's probably most familiar would be HIPAA, the Health Insurance Portability and Privacy Act. At the state level, you've got a body of statutes that that apply to the Cabinet for Health and Family Services, at least in the family services context. I'm not so sure in the public health context, but ultimately you've got a body of confidentiality statutes in both state and federal law that are deemed incorporated into the Open Meetings Law by operation of KRS 618101K. So if the statute requires the matters to be discussed privately, that portion of the meeting can be conducted in closed session. We've recently issued an opinion involving unemployment insurance cases, which have confidentiality provisions that apply to those discussions, recognizing that those discussions could be conducted in closed session. Maybe not the entire meeting, but that part of the discussion. Okay, and since 2005, Kentucky has not. This probably will not have direct relevance to your agencies, but it's important to know that since 2005, Kentucky has had what is basically a Homeland Security exemption to the Open Records Law, which is correlated to a provision of the Open Meetings Law. If you have a record that qualifies for protection under the Homeland Security exception to the Open Records Law, any discussion of that record can be conducted in a closed session under this provision, 618101M, which again is I think the newest exception to the Open Meetings Law, and very narrowly crafted exception to the Open Records Law can only be invoked under very specific circumstances. So it's going to be the rarest of occasions where this will be applicable, but it does now exist in the law, and one of the few instances where the General Assembly did correlate the exception to the Open Records Law to an exception to the Open Meetings Law. So that's helpful. This is very important, and I want to stress this. When the law was first enacted and over time, there was a recognition that there was a recurring problem of what's called a rolling quorum. Essentially, you didn't have a secret meeting of a quorum of the members of a public agency, but you had a series of less than quorum meetings where the members attending one or more of the meetings collectively constituted at least a quorum. The county judge would call one of the members of the fiscal court into his office, then he'd phone another member of the fiscal court, and he'd run into two more, and he'd ultimately basically get the discussion would all take place outside the public forum. Decisions would be made without any kind of public discussion. And in response to that, the General Assembly in 1992 introduced this language, basically subjecting to the requirements of the Open Records Act any series of less than quorum meetings where the members attending one or more of the meetings collectively constitute at least a quorum if, and this makes it a little bit difficult, if the intent of the members is to circumvent the requirements of the Act. One of the problems for our office since this provision has been enacted is determining what the intent of the parties is when they conduct this series of less than quorum meetings. Of course, they're generally going to say it was not our intention to violate the law. It just happened. You know, that's a very common defense. We didn't intend to violate the law. Well, I can only tell you that if you have this series of less than quorum meetings and the members attending one or more of the meetings collectively constitute a quorum, the likelihood is the decision rendered by the Attorney General will state that the agency, to the extent it can engaged in that conduct, violated the Open Records Law. We can't determine the subjective intent of the participants in that meeting, but we will generally say that that course of conduct falls within the zone of prohibited conduct. There is also the statement, the last sentence, again, a little bit of wiggle room that the General Assembly put in the statute. Nothing in this subsection shall be construed to prohibit discussions between individual members where the purpose of the discussions is to educate the members on specific issues. I can't tell you how often, including today, someone said to me, well, we were just trying to educate each other. It was just our goal to just educate each other, so we really didn't violate the law. Well, that really, it is a defense that can be raised. I can only tell you that I think it's sort of the last resort. It certainly should not be raised in any other context. This idea that you can generally say a secret meeting is permissible if it's only held for the purpose of educating the members is not going to fly. You might be able to raise it in this context, but again, I would just really strive to avoid a series of less than quorum meetings where the members attending one or more collectively constitute at least a quorum. It's contrary to the spirit of the law. It's contrary in many instances to the letter of the law if a subjective intent to violate the law can be established, and it should just be avoided, in my view, at all costs. Again, there's a case called Yeoman versus Commonwealth where the Supreme Court dealt with this particular provision of the law and said that the act prohibits a quorum from discussing public business in private or meeting in number less than a quorum for the express purpose of avoiding the open meetings requirements of the act. So a secret meeting of a quorum or a series of less than quorum meetings held for the purposes of avoiding the requirements of the act. Both fall within the zone of prohibited conduct and obviously have to be avoided. I'm not going to spend a lot of time on this because I'm running short of time, but I did want to mention, of course, one of the big developments in the last 10, 20 years has been the use of electronic devices instead of face-to-face contact. I think probably, there's a threat to public access that this kind of communication poses that really concerns me. Again, I just want to mention that when you're dealing with personal electronic devices or publicly issued electronic devices, the records that you create may be accessible to the public depending on their content. We know absolutely that if you're using a public electronic device, a publicly issued device, and discussing public business, texting, emailing, whatever, that is almost certainly accessible under the Open Records Law, may run afoul of the Open Meetings Law by constituting, if it's shared with enough people, a series of less than quorum meetings where the members attending virtually constitute a quorum of the members of the public agencies. We know that publicly issued equipment, public communications on public business may be accessible. We also know that use of a publicly issued device to discuss private business, like personal business, can also be accessible under the Open Records Law. So you have to keep that in mind if you've been issued I don't know what anything's called, smartphone. I don't know what things are called now. But ultimately, if you have a device that has been issued by your employer, your board, but if you have a publicly issued device and you're discussing matters that are of a personal nature, that could be accessible as well. I know that's hard to swallow, but there's actually some circuit court opinions that establish that principle. As far as privately owned equipment and discussion of public business, which probably will implicate or could potentially implicate a board member, absolutely be thinking in terms of that. With the way Kentucky's law has been construed, the way it's being construed across the country, there's every likelihood that could be deemed a public record as well. So even if it's your private device, if you're conducting public business on that device, those records may be accessible, and you may again be engaging in conduct that constitutes a violation of the Open Meetings Law if you have that series of less than quorum meetings, even though they're kind of these virtual meetings. Again, as I have in the PowerPoint, our statute supports a similar resolution of these legal issues as it's been resolved in a lot of jurisdictions already. We already have other jurisdictions who have weighed in on these issues, and in many cases have been resolved in favor of public access. So I would just encourage you to think before you write, text, email, instant message, post on Facebook, any of those types of things. If the matters under discussion relate to the agency's public business, those messages may be accessible under the Open Records Act and may run afoul of the Open Meetings Act. Okay. I mentioned at the beginning of the presentation, and I will have to run through this very quickly, but there is a complaint process. If a person attends your meeting or becomes aware that you're conducting a meeting and has some grievance or concern about the way you conducted that meeting, They can challenge your meeting by filing a complaint with the Attorney General. They don't have to hire an attorney. They don't have to pay a filing fee. They basically start by sending the presiding officer of the public agency a written complaint in which they state the circumstances of the alleged violation and propose a remedy. Having done that, their duties are fully discharged. It then shifts to you as the public agency to respond within 3 business days in writing. You can acknowledge the violation if you believe they're on solid ground and just agree to comply with the remedies that they've proposed. Or if you believe that you have a legitimate defense to their allegations, you basically respond within 3 business days, and that written response should cite the specific statute supporting the agency's position and explain how that statute supports the agency's position. And again, you would be declining to implement the proposed remedial action. So don't let that 3 days go by without taking some sort of action, because that in itself would be a violation of the open meetings law. Failing to respond to an open meetings complaint is itself a violation of the open meetings law. But again, the complainant has very little responsibility. I mean, it's just not hard to do this. You know, you just file that written complaint with the presiding officer, state the circumstances of the violation, propose a remedy, U.S. mail it, fax it, or hand deliver it to the agency, and that's going to trigger that 3-day response time in which the agency has to respond. The Attorney General, upon receipt of an appeal, if the agency denies that a violation has occurred or if the agency fails to respond to the complaint, very often people will bring their appeals to the Attorney General. They can bypass us and go directly to circuit court, but they're going to pay a filing fee. It's going to be a lot longer before they get a decision, so typically they come to the AG first. We will issue a notification. You will be notified as soon as we humanly can notify you. We fax those notifications so that you have them as soon as possible, because ultimately this whole process is a 10 business day process. So it's a very quick turnaround on open meetings violations, open meetings complaints. We may ask you for some additional documentation to substantiate your agency's position, but in any event, you know, we're going to review that complaint, we're going to review the agency's written denial, and after 10 days have elapsed, we're going to issue a decision stating whether the agency violated the Open Meetings Act. If that decision is not appealed to circuit court within 30 days, it has the force and effect of law and binds the parties. There is a requirement in open meetings that appeal be filed within 60 days of the denial. So the person files the complaint, your agency responds, you deny that the violation occurred, they have to bring their complaint to the Attorney General within 60 days. If they don't do it, their complaint is time barred. There is no similar provision in the open records law, but they do have to bring their complaint within 60 days. We don't reconsider our opinions. There is a mechanism in the statute for appealing our decisions to circuit court, and given the volume of appeals that we receive, we have a regulation that prohibits us from reconsidering them. So if you're dissatisfied with the decision the Attorney General renders, you should consider an appeal to circuit court. We don't have the ability to compel implementation of a proposed remedy. We're simply going to say we believe that a violation of the open meetings law did or did not occur. We're not going to say anything about the proposed remedies. There are penalties in the statute. That's a frequently asked question is, what are the penalties? Well, there are penalties in the statute. They're not terrifically onerous penalties, but there are penalties. If a person knowingly attends a meeting that violates the Open Meetings Act, a court can fine him or her up to $100. The Attorney General, again, can't impose penalties. Only the courts can impose those penalties. But a person can be fined. If a member of the public agency attends a meeting that he knows is violating, he knows there was inadequate notice, he knows that this is a secret meeting. If he knowingly attends a secret meeting, if he does that, he can be fined up to $100. The prevailing party in an open meetings lawsuit can be awarded costs, including reasonable attorney's fees, as well as up to $100 for each violation. And most importantly, especially if you have significant action taken at an illegal meeting, a court can void the action taken, and has recently done that. The case I cited earlier, Carter v. Smith, I think is the name of the case, the court voided a very significant contract that was basically implemented at an illegal meeting. And in Carter v. Smith, the court said you can't just ratify action improperly taken by simply taking a vote in open session without any discussion. So the courts are coming down pretty heavily in favor of the public's right to know. at the conclusion, and I don't know if you're going to be able to read these or have access to these, but I have literally put into a synopsis form that I believe 10 or 11 most commonly cited exceptions to, 10 most commonly cited violations of the open meetings law, and it might not be a bad idea if you have an opportunity to take a look at those. But I would like to close and thank you for your attendance and attention today. I just want to mention this is my light moment because I think I've been a little tedious. If you look at the little box in there, this is a judge in Cincinnati talking about Ohio's open meeting statute. Interpreting this law is very difficult. Whoever wrote it should be taken out and shot, and they don't need to have an executive session to do it. I just like that quotation, so I like to end on that note. Thank you again for listening this evening, and if you have any questions, I'll be happy to try to take those questions. If you ever need to call me, feel free to do so. Thank you.